Let's then put the spotlight on what's happening as far as Elon Musk-owned Corp is concerned. Well, in a big setback to Corp, the Karnataka High Court yesterday rejected a petition filed by the social media platform. The plea was filed challenging the centre's direction to social media platforms to join the Central Sahyog portal set up to issue content takedown orders. But the High Court has said that content on social media needs to be regulated, and the court did not find merit in the issues that were raised by Corp. Remember, Corp approached the High Court in March this year, claiming that Sahyog portal for issuing takedown orders lacked the statutory backing. In fact, even argued that the innocuously named Sahyog portal was used to issue illegal content blocking orders that bypass statutory safeguards. In fact, the court has said that social media cannot be left in a state of anarchic freedom and warned that unregulated speech could lead to lawlessness. In fact, to discuss that and more, now joined by Ms. Nappinal. She's a senior advocate at the Supreme Court. Thank you very much, Ms. Nappinal, for taking the time out and speaking to us here on ET Now. Now, referring to the case, is a critical matter, critical order by the Government of India, a critical order by the High Court, Karnataka High Court, which has been issued. How do you see this order, which essentially states that takedown orders can be given? It even goes on further so as to say that matters cannot be left in a state of anarchic freedom.
Absolutely right. See, when you have a takedown order, that's also still ring-fenced by what is permissible and impermissible in law. It's not like it's an order that can be issued with, without any kind of guardrails or with a kind of like absoluteness where the government does not have to give reasons or rationale behind it. How the law works is you have two provisions. One,
all right, Ms. Nappinal, we seem to have lost that connection with you. We'll try and re-establish that connection with Ms. Nappinal in just a moment. But ladies and gentlemen, we're discussing the big ruling by the Karnataka High Court yesterday, which actually rejected a petition that was filed by the social media platform Corp. In fact, the plea was filed challenging the centre's direction to social media platforms to join the Central Sahyog portal that was set up to issue content takedown orders. In fact, I'm given to understand that Ms. Nappinal is back with us on the live feed. Ms. Nappinal, if I could ask you once again, this order that's been passed by the Karnataka High Court is a critical one. How do you see this order, which essentially states that takedown orders can be issued by government?
My apologies for terrible network connectivity, but very quickly. Firstly, the Karnataka High Court judgment upholds what the Supreme Court itself has said when it struck down 66A but upheld 69A, which is for blocking of content, which is where an order is predicated by due process, then it has to be upheld. Similarly, when you talk about takedowns, that comes under 79 of the IT Act, where again, a very detailed list of what are all permissible and impermissible content is already captured under the intermediary guidelines. And if something is violative and where a reasoned order is passed, then a takedown order is well within the remit of constitutionality. Effectively, this is what Karnataka High Court judgment seems to be emphasizing.
Right, ma'am. In fact, let me ask you one more question on this. Why might a company comply with takedown laws in one country but resist similar laws in another?
Well, that's for the company to answer, but it's a very critical question that you raise, which is that a company which is extending its services within a jurisdiction, in this instance within India, and is benefiting from that subscription from various users from India, has to necessarily comply with the laws of the land. They cannot shy away from the fact that they are bound by the laws and they have to comply where it's within the remit of law, and where they have an issue with respect to violation of fundamental rights or otherwise, they have to follow the procedure established in law, which is to go before a court and contest their claim. They cannot take a stand that I'm a company registered in the US and I'm not amenable to your laws, or that I will not comply with it. Here, in the intermediary guidelines, you have a very clear provision which says that if you do not comply with the takedown order for India, as in this instance, then you could be held liable on par with the person violating the law by the posting of some content. So if that is the case, and this draws its rights from Section 79 itself, when a company says they will not comply, they run the risk of then being held as co-collaborators in a crime. So therefore, it is for each platform to understand that they are bound by the laws of India and they have to comply with it if they are extending their services to Indian users.
Right, ma'am. In fact, let me ask you another question as far as this particular case is concerned. Are there any protections which can be given for companies like X Corp under international law, which could perhaps override these Indian regulations?
I would say it is there even within Indian laws. It's not like this is some kind of an absolute order which you have to comply or you have no other alternative. The law itself provides for a review. The law provides for you to raise an objection. And if nothing works, then you can also go before courts and seek your remedies. So this is there within the Indian perspective itself. In international, it gets even more complicated. But an international conflict of law situation will not help a platform like Twitter, which is primarily contesting an issue which doesn't fall within the parameters of international law, but of municipal laws.
Right, Mr. Nappinal, thank you very much for taking the time out and speaking to us here on ET Now. So, of course, the big direction that's coming in from the Karnataka High Court that, of course, regulations have to be followed, the law of the land has to be followed, and arbitrariness is something that brands and companies must avoid, and social media must be regulated. So that's the big, commentary that's coming in from the Karnataka High Court, also suggesting that India's resolve should not be termed as unlawful. In fact, those very strong words coming in from the Karnataka High Court as far as X Corp's case with respect to the government of India as far as that is concerned. Definitely that's going to set a precedent for many other cases that will come up in this regard when it comes to being accountable and when it comes to expressing freedom of speech and expression. Well, on that note, ladies and gentlemen, it's time now for us to slip into a very short commercial break, but lots more coming up on the other side. You don't want to